Chapter 21. Lands and Natural Resources. Part 1. Public Lands. Article 257. Public Lands and Other Public Property. 1. All public lands in Ghana shall be vested in the President on behalf of, and in trust for, the people of Ghana. 2. For the purposes of this article, and subject to Clause 3 of this article, public lands includes any land which, immediately before the coming into force of this Constitution, was vested in the Government of Ghana on behalf of, and in trust for, the people of Ghana for the public service of Ghana, and any other land acquired in the public interest, for the purposes of the Government of Ghana before, on, or after that date. 3. For the avoidance of doubt, it is hereby declared that all lands in the northern, upper east and upper west regions of Ghana which immediately before the coming into force of this Constitution were vested in the Government of Ghana are not public lands within the meaning of clauses 1 and 2 of this article. 4. Subject to the provisions of this Constitution, all lands referred to in clause 3 of this article shall vest in any person who was the owner of the land before the vesting, or in the appropriate scheme without further assurance than this clause. 5. Clauses 3 and 4 of this article shall be without prejudice to the vesting by the government in itself of any land which is required in the public interest for public purposes. 6. Every mineral in its natural state in, under or upon any land in Ghana, rivers, streams, watercourses throughout Ghana, the exclusive economic zone and any area covered by the territorial sea or continental shelf is the property of the Republic of Ghana and shall be vested in the President on behalf of, and in trust for the people of Ghana. Skips Articles 258 to 265. Part 2. Ownership of land by non-citizens. Article 266. Ownership of land by non-citizens. 1. No interest in or right over any land in Ghana shall be created which vests in a person who is not a citizen of Ghana a freehold interest in any land in Ghana. 2. An agreement, deed or conveyance of whatever nature, which seeks, contrary to clause 1 of this article, to confer on a person who is not a citizen of Ghana any freehold interest in, or right over, any land is void. 3. Where, on the 22nd day of August 1969, any person not being a citizen of Ghana had a freehold interest in or right over any land in Ghana, that interest or right shall be deemed to be a leasehold interest for a period of 50 years at a peppercorn rent commencing from the 22nd day of August 1969, and the freehold reversionary interest in any such land shall vest in the President on behalf of, and in trust for, the people of Ghana. 4. No interest in or right over any land in Ghana shall be created which vests in a person who is not a citizen of Ghana a leasehold for a term of more than 50 years at any one time. 5. Where on the 22nd day of August 1969 any person not being a citizen of Ghana had a leasehold interest in, or right over, any land in Ghana for an unexpired period of more than 50 years. That interest in, or right over, any such land shall be deemed to be an interest or right subsisting for a period of 50 years commencing from the 22nd day of August 1969. Part 3. Stool and skin lands and property. Article 267. Stool and skin lands and property. 1. All stool lands in Ghana shall vest in the appropriate stool on behalf of, and in trust for the subjects of the stool in accordance with customary law and usage. 2. There shall be established the office of the administrator of stool lands which shall be responsible 4. A. The establishment of a stool land account for each stool into which shall be paid all rents, dues, royalties, revenues, or other payments whether in the nature of income or capital from the stool lands. B. The collection of all such rents, dues, royalties, revenues or other payments whether in the nature of income or capital, and to account for them to the beneficiaries specified in Clause 6 of this article, and c. the disbursement of such revenues as may be determined in accordance with Clause 6 of this article. 3. There shall be no disposition or development of any stool land unless the Regional Lands Commission of the region in which the land is situated has certified that the disposition or development is consistent with the development plan drawn up or approved by the planning authority for the area concerned. 4. Where the Regional Lands Commission fails or refuses to give the consent and concurrence under Clause 3 of this article, a person aggrieved by the failure or refusal may appeal to the High Court. 5. Subject to the provisions of this Constitution, no interest in, or right over, any stool land in Ghana shall be created which vests in any person or body of persons a freehold interest howsoever described. 6. 10% of the revenue accruing from stool lands shall be paid to the office of the administrator of stool lands to cover administrative expenses, and the remaining revenue shall be disbursed in the following proportions. A. 25% to the stool through the traditional authority for the maintenance of the stool in keeping with its status. B. 20% to the traditional authority, and c. 55% to the district assembly, within the area of authority of which the stool lands are situated. 7. The administrator of stool lands and the Regional Lands Commission shall consult with the stools and other traditional authorities in all matters relating to the administration and development of stool land and shall make available to them all relevant information and data. 8. The Lands Commission and the administrator of stool lands shall coordinate with all relevant public agencies and traditional authorities and stools in preparing a policy framework for the rational and productive development and management of stool lands. 9. Parliament may provide for the establishment of regional branches of the Office of the Administrator of Stool Lands to perform, subject to the directions of the Administrator of Stool Lands, the functions of the administrator in the region concerned. Part 4. Protecting natural resources. Article 268 Parliamentary ratification of agreements relating to natural resources. 1. Any transaction, contract, or undertaking involving the grant of a right or concession by or on behalf of any person including the Government of Ghana, to any other person or body of persons howsoever described, for the exploitation of any mineral, water or other natural resource of Ghana made or entered into after the coming into force of this Constitution shall be subject to ratification by Parliament. 2. Parliament may, by resolution supported by the votes of not less than 2/3 of all the members of Parliament, exempt from the provisions of Clause 1 of this article any particular class of transactions, contracts or undertakings. Article 269 Natural Resources Commissions. 1. Subject to the provisions of this Constitution, Parliament shall, by or under an Act of Parliament, provide for the establishment, within 6 months after Parliament first meets after the coming into force of this Constitution, of a Minerals Commission, a Forestry Commission, Fisheries Commission, and such other commissions as Parliament may determine, which shall be responsible for the regulation and management of the utilization of the natural resources concerned and the coordination of the policies in relation to them. 2. Notwithstanding Article 268 of this Constitution, Parliament may, upon the recommendation of any of the commissions established by virtue of Clause 1 of this article, and upon such conditions as Parliament may prescribe, authorize any other agency of government to approve the grant of rights, concessions or contracts in respect of the exploitation of any mineral, water or other natural resource of Ghana,